On behalf of the Florida Workers' Compensation Institute, the National Workers' Compensation Institute, and the Office of Judges of Compensation Claims, I want to welcome you to the third annual educational seminar and the litigation program that has been going on for the past 3 years in this courthouse. We particularly thank the First District Court of Appeals for allowing the seminars to be held here. We are particularly pleased that they, as a part of the judicial process, have recognized that workers' compensation is indeed an important part of the practice of law and law in general, and not always the case when you're dealing with different courts. A couple of announcements before we begin. If you are here to get continuing education credits as an adjuster or as an agent, or you're seeking continuing legal education courses, you need to register, or credits, so you need to register downstairs at the registration desk. We will give you a proof that you were here in attendance, and we'll register your presence with the regulator. So be sure to check in at the desk. The program for today's seminar is on the first page of the handout, and as you will notice, we have a break in the morning and a break in the afternoon. Lunch is provided by us. It will be in the rotunda area, and certainly it's complimentary. We stop the seminar this afternoon at 3:30. You're going to leave at 3:30 anyway, so we might as well go ahead and stop it then. That will allow you to beat the traffic. But any questions that you have during the day, please be sure to contact the registration desk, and they certainly can provide what information that is needed. It really is a unique honor for us with the Florida Workers' Compensation Institute and the National Workers' Compensation Institute to be a part of this session. My name is Jim McConaughey, and I'm the chairman of the Florida Workers' Compensation Institute and the National newly formed Workers' Compensation Institute. Any seminar that's sponsored by the Judges of Compensation Claims and supported by the First District Court of Appeals is something that we definitely want to be a part of. As you all know, the Judges of Compensation Claims and the First DCA represent the entire judicial system in the workers' compensation area. And I think both of these institutions are rarely recognized for their many contributions and accomplishments and the things that they do for the workers' compensation industry as a whole. Oftentimes they are maligned and criticized, but indeed they represent the very backbone of the Florida workers' compensation system. The judges are 30 in number throughout the state of Florida. I've been practicing workers' compensation law, I hate to admit, in excess of 40 years, and I think this is honestly the best group of judges that we've ever had. Don't necessarily agree how they decide, but we've got the best group of judges ever. And I think the newest judge, Judge Mark Massey, I saw him here earlier, is indicative of the quality of judges that we're now getting. Welcome to the bench, Your Honor, and we know that you'll have a long and successful career in workers' compensation. And I can't go without mentioning the fact that Judge Langham, who is the Chief Judge of Compensation Claims here today, he is indeed the one that created the whole idea of this seminar, and is to be recognized for his many accomplishments as the Chief Judge. As I said, the very idea of this conference was his, and the things that he has accomplished in the automation of the judicial system in workers' compensation is just astounding, and I think far exceeds what is seen in the other judicial processes. The First District Court of Appeals took over the workers' compensation appeals in the late 1970s. And since that time, they have literally reviewed thousands and thousands of cases. And they've gone through almost every idea that the legislature has come up with as far as curing the workers' compensation system, beginning with wage laws when they were first created and going through all the different systems that we've had that have been the ideas of others. They are the ones that really tell us what those systems are. Their contributions to the workers' compensation educational system is certainly, again, not recognized, well recognized. As perhaps you know, we at the Florida Workers' Compensation Institute and the Workers' Compensation Institute sponsor an educational conference in Orlando in August of each year. We began that effort in 1986 with 300 attendees, and now we have in excess of 8,000. And we rebranded the conference recently as a national conference as opposed to a state-specific conference. But I will tell you that the very foundation of that conference depends upon the Florida Workers' Compensation laws and the educational processes associated with Florida's workers' comp system, and the very basis of the very foundation of that Florida presentation is based on the participation of the First District Court of Appeals. Even though we label ourselves a national conference, we still are heavily involved with teaching workers' compensation in Florida. And if you will remember or notice the program that's continuous, we have breakouts on case law updates, and that's interpreting what the First District Court of Appeals says. Adjuster breakouts are adjuster breakouts for Florida adjusters that deal with Florida workers' compensation issues. The attorney breakouts, if you will notice in the program, are dealing with general attorney breakouts that are of concern to all attorneys throughout the United States, but mainly to Florida issues, heart and hypertension breakouts. Many of the medical breakouts, the mediation process, all relate to the input that the First District Court of Appeals has provided as an educational process to the convention. The moot court competition is named after a First District Court of Appeals Judge, Earl Zemer, and we've been doing that since his death some 10 or 15 years ago. And I think the most unique part of the conference as a whole is the oral argument. And this is a live case that the First District Court of Appeals puts on every year. It's a real case, two real cases, and they, in an unprecedented way, I think, have for years come down and put that particular part of the conference on. I always like to say that the conference is a partnership of partnerships, and partners who contribute toward the success of the conference is no one person. But I will tell you that there is no partnership more important to us and to the conference as a whole as the First District Court of Appeals. In that regard, I'd like to give special recognition to John Wheeler, who is the clerk of the First District Court of Appeals, who has contributed really so many things to make that a success. It is at this time that it's my privilege to introduce to you the Honorable Robert Benton, who is the Chief Judge of the First District Court of Appeals, who has been, again, a real supporter of our industry, a real supporter of the conference, and again, without whose cooperation and input, we would not have the comp system that we have in Florida, and certainly would not have the conference that they so much contribute toward the success of. So, Judge Benton, we'd like to introduce you at this time.
Well, thank you, Jim. And I just basically wanted to take a minute to tell you that I'm glad you're all here, and I wish you a productive few hours here. And I noticed the title, The New Reality of Workers' Compensation Litigation, and it seems a little magnificent, the title, in a way, but it has changed. I remember my first contact was when I was working as a law clerk at the Supreme Court of Florida, and at that time, there was review by the Supreme Court of the Industrial Relations Commission's orders, which they were an administrative reviewing body of the deputy commissioner's work. And so the things have certainly, and then as Mr. McConaughey mentioned, everything was shifted to the District Court of Appeal in the 70s, well before I got here. And so there have been and then for a while, we had that sort of hybrid situation where, of course, there's always been executive branch adjudication, but the Supreme Court promulgated the rules for a while. And now I think we've got things kind of straightened out in terms of Florida con law with where DOA's in the picture, and but the beat goes on. So you all going to learn about the new reality today, and I don't want to delay that. And I do hope you have a good day.
Thank you, Judge. The agenda for today's program is again found on page 1 of the handout. The first panel will be Christopher Smith as moderator, and I guess the panel will sit up here. Just for your information, this breakout, or this session will be held here. We'll take a break, and then it will resume downstairs in the general meeting room. So after the break, be sure to the break will be downstairs also, and then we'll continue with the program downstairs. So, Christopher.
Well, good morning, everyone. Thank you for being here. This is our first session. It's entitled Ethical Issues in Workers' Compensation. My name is Christopher Smith. I'm an attorney in Tampa. It is my distinct pleasure to introduce our speakers this morning. In the middle, we have the Honorable Diane Beck, Judge of Compensation Claims from Sarasota. To my immediate right is the Honorable John Lazzara, Judge of Compensation Claims from Tallahassee. And to my far right is the Honorable Daniel Lewis, Judge of Compensation Claims from Fort Lauderdale. Our program will run for 50 minutes, and to allow the program to run as smoothly as possible, I would simply ask that you hold off on asking any questions until the very end. We'll try to reserve about 5 minutes at the conclusion of our presentation. Now, again, our title this morning is Ethical Issues in Workers' Compensation, and for the purpose of a brief overview, I can tell you that we've divided the presentation into essentially 3 different sections. Ethics and professionalism in dealings between the parties and the court, ethics and professionalism in the context of fees, costs, and the settlement process, and then a brief look at current trends in litigation. Now, Judge Lewis, I'd like you to begin the program for us this morning. We hear the concepts, we've used the concept ethics and professionalism. Is there a distinction between these two concepts from your perspective?
Well, thank you, Chris, and good morning, everybody. And as Mr. McConaughey said, it's a great privilege to be here. But a famous person once said, as we know there are known knowns, there are things we know we know. We also know there are known unknowns. That is to say, we know there are some things we do not know. But there are also unknown unknowns, the ones we don't know we don't know. That pretty well sums up the workers' compensation law as it exists today in Florida. I'm here to talk to you today about the known knowns of ethics and professionalism. Any questions that you may have regarding known unknowns and unknown unknowns will be deferred to my colleagues on the panel. Attorneys are officers of the court. You all know that expression. But you may not know that it means the representations made by counsel to a court or a judge are akin to sworn testimony. And that's per the case of Morrison Management Specialist versus Pierre. And by the way, all the case and article citations are in my outline handout. You also know the expression, attorneys have a duty to zealously represent their clients. But you may not know. Case law tells us that duty should not be elevated over all other duties. In the case of Boca Berger versus Forum, our Florida Supreme Court observed that counsel must be governed by considerations other than mere zealous advocacy for the client. As stated in that case, too many members of the bar practice with complete ignorance of or disdain for the basic principle that a lawyer's duty to his calling and to the administration of justice far outweighs and must outweigh even his obligation to his client. As that case tells us, the heart of all legal ethics is in the lawyer's duty of candor to the tribunal. Outcomes should not depend on which attorney is the most eloquent, the most persistent, or best able to misdirect the judge. In fact, Rule of Professional Conduct 4-3.3a of the rules regulating the Florida Bar provides that a lawyer shall not knowingly make a false statement of material fact or law to a tribunal or fail to correct a false statement of material fact or law previously made by the attorney to the tribunal. In his article, Professionalism Considerations in Oral and Written Advocacy, U.S. Magistrate and former First DCA Judge Charles Kahn states that legal ethics are disciplinary standards, that is, the rules of the Florida bar. Professionalism, on the other hand, involves aspirational type standards. As Judge Kahn observes, it's possible for lawyers to be unprincipled and untrustworthy without necessarily running afoul of the legal ethics code. Judge Kahn tells us professionalism requires that courtesy and respect be shown to clients, opposing counsel, and the court. As psychologically purging as it may be, it's not professional to engage in personal attacks on opposing counsel, to accuse your opposing counsel of lying, or to disparage the tribunal. As Attorney Michael Tanner put it in his article, Basic Steps for Good Peer Review, the true mark of a professional is being courteous and respectful to others, even when you think they don't deserve it. Judge Kahn reminds us that preparation is the hallmark of professional advocacy. He cites instances where, in response to questions by the appellate court, an attorney will say, "I'm sorry, I didn't try the case, so I don't know the answer." That happens in our hearings as well. When I've asked a question, I've been told on occasion, "This isn't my case, I'm just handling this hearing for another attorney in the office." Be prepared. Retired First DCA Judge Peter Webster observes, it's not uncommon to see personal attacks on the appellate court, lower tribunals, or on opposing counsel in appellate briefs and pleadings. In his article, Ethics and Professionalism on Appeal, Judge Webster discusses instances where the trial judge's findings were referred to as baloney, cockeyed and absurd, or demonstrating a startling absence of legal knowledge. I hope none of those are my cases, actually. Judge Webster tells us a motion for rehearing is not an open invitation for the litigant or attorney to convey the bottomless depth of the displeasure they feel towards the court or the tribunal. Judge Webster notes that in one motion for rehearing, an attorney wrote, "This appellate court has either ignored the law or is not interested in determining the law. Rule of Professional Conduct 4-8.2, which is entitled Impugning Qualifications and Integrity of Judges or Other Officers, states, a lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to its truth or falsity concerning the qualifications or integrity of a judge, a mediator, an arbitrator, an adjudicating officer, a public legal officer, a juror or member of the venire, or a candidate for election or appointment to judicial or legal office." Judge Webster reminds us that the oath of admission to the Florida bar requires applicants to swear to maintain the respect due to the court and judicial officers and to abstain from all offensive personality. As you know, the oath was amended by the Florida Supreme Court in September 2011 to also require applicants to pledge fairness, integrity, and civility to opposing parties and their counsel, not only in court, but in all oral and written communications. This amendment arose due to the perception of a lack of civility in the adversarial process. How many of you here have noticed any lack of civility in the adversarial or legal process? Any of you? Okay, some of you. As Judge Webster tells us, an attorney is, first and foremost, an officer of the court bound to serve the ends of justice with openness, candor, and fairness. So when you file a pleading with a judge, give a moment's pause to reflect on how that judge will feel if you stoop to insulting him or her while simultaneously requesting relief. Remember that a lawyer's duty to her calling and the administration of justice far outweighs even her obligations to her client.
Thank you very much, Judge Lewis. Judge Beck, we know that part of the ethical obligations that the attorneys owe to each other and to the court is to make certain that they have fully complied with both the spirit and letter of all applicable statutes and rules. Rule 60Q 6.115 subsection 2 requires that the attorney shall certify prior to the filing of a motion that he or she has either personally conferred or used good faith efforts to confer with all parties or their attorney of record, and shall state whether any party has an objection to the motion. I have a couple of questions for you. In the digital age, from your perspective, what does personally confer require? Does it require an actual phone call, an exchange of emails? What does it require?
Well, I used to say that it did require a phone call between counsel. I can surely tell you what it does not include, and it should not include a secretary to a secretary or a legal assistant to a legal assistant. Even letters, I think, don't quite fit the bill, and I will frequently see a motion that will attach a letter that says something like, here's a copy of my motion. If you don't respond within 5 days, 10 days, whatever, I'm going to file it with the court. But I think that a phone call, an attorney to an attorney, it's really hard to say, I object when you're talking to somebody else without at least giving some kind of reason for it or without discussing the merits. But over the last couple of years, I've kind of changed my opinion a little bit, and I do think that emails can suffice, because I'm seeing more and more of a course of conduct amongst attorneys and between staff that shows that really the reality of today's work is you do use email for everything. And I'll see it on occasion when somebody moves to enforce, and they'll send me a whole string of emails between each other showing how their course of dealing has been and what their negotiations have been. And many, many defense counsel communicate solely with their clients via email. And I'm doing it myself. I communicate more with my own family through email than I probably do via telephone. So I'm not coming to the idea that email is okay as long as you already have that course of dealing with opposing counsel. If you're comfortable with each other and with using that, and that's your primary method, then I think it's good to handle it that way. But again, like a letter, it's kind of easier to say no or to say I object when you're only doing it in writing and you're not actually talking with someone personally.
Thank you. Now, we know that we're all engaged in very busy practices, and sometimes the question becomes if there's an inability to actually confer either digitally or over the telephone, the other portion of the rule states that the individual must certify that he or she has used good faith efforts to confer. What constitutes, in your judgment, a good faith effort to confer? And specifically, I guess I'm asking is how long must one wait for a response from opposing counsel to either an email or an attempt to speak directly over the telephone before filing a motion?
I think that's always going to be factual based. In other words, if you're up against an emergency and you have to file a motion to for protection against something, you maybe can't wait 48 hours because what you're seeking protection against is coming up within an earlier time frame. So sometimes you do have to shorten the time frame. And again, if you call opposing counsel and you're told by his staff, oh, opposing counsel's on vacation, or opposing counsel's arguing at the District Court of Appeals and can't be reached for a couple days, well, then I think you do have to give them some leeway. But generally speaking, what I used to tell the attorneys in my district was, if you call and ask to personally speak to opposing counsel and they keep pushing you off, or you keep getting the, he's not here, or she's not here, and they won't return the calls, I tell them, you say, Judge Beck said that you are to ask for a time specific on that attorney's calendar when you can call back and speak with them. And if they've done that and the opposing counsel still won't talk to them, then I'm not going to listen if that counsel comes in and says, wait a minute, they never personally contacted me before filing this motion. So I think that there are ways that you can ensure that you'll be able to communicate with someone in a timely fashion, but it's going to be somewhat fact-based on that other person's schedule. But in generally speaking, 24 hours ought to be enough for somebody to get back to you.
Judge Beck, again, staying with you, in our preparations for this seminar, you indicated that another area where, in your experience, professionalism was often compromised is with regard to responses to requests for discovery, which leads me to a couple of questions. From your perspective, what problems occur in situations where a party is unable to receive a response to a request to produce in a timely fashion?
Well, now, and of course, we've always been under time constraints in workers' compensation. Now we have to bring a case to mediation within 130 days and to final hearing within 210 days in most cases. And so if you don't have the necessary information that you need to either prosecute a case or defend it, you can be in trouble. And particularly in this day and age when fraud raises its ugly head a lot. And, you know, it's difficult for most people to remember things in their remote past. And so if you can't get copies of what happened to a person so that they can at least review them before they have their deposition taken. There is a danger that they're not going to remember something that the opposing side is going to come back to them and say, well, you lied. You didn't tell me that you had a car wreck 40 years ago and hurt yourself. Also, even things as simple as the average weekly wage are difficult to figure out if you don't get the information. I don't know what it is about most claimants that I see, but they simply don't keep records. None have a pay stub or an IRS return, and so they don't know a lot of times what they were earning. And even to be able to establish that, coupled with the idea that you do have to raise every claim that's ripe, due, and owing, or it might be considered res judicata. So in order to know if you even have a claim concerning the average weekly wage, you need to know where that is. And when people don't respond, it sort of prolongs the agony. All of a sudden you're running into that 130 days, then you're running into that 210, and you're either not able to state the claims that you need to state because you don't have enough information about the case, or you're not able to defend because you don't have enough information about the case.
Can I just mention something on that? Incidentally, it's absolutely awesome to sit up here. This is really an experience. Wow. But anyway, let me just state some of the problems I see, especially with motions to compel production, is that carriers really don't take the request to produce seriously, and especially when they're not represented by legal counsel in the beginning of a claim. And invariably, those resolve once defense counsel gets involved in the case, and usually the production is forthcoming. But it really does delay, as Judge Beck stated, number one, the discovery process, and number two, probably more importantly, is having that information available for purposes of mediation, especially the AWW. Too bad there isn't a way we can capture that electronically, either through the Division of Workers' Comp with respect to the AWW, but that seems to present a problem because that's an issue that certainly can be resolved at mediation if produced early enough.
Thank you, Judge Lazzara. Judge Beck, another component of the discovery process is depositions. Are you finding that parties coming before you seeking continuances do so occasionally because they allege a refusal of their opponent to either make a witness, such as an adjuster, available in a timely fashion, or make themselves available for needed medical depositions? What position do you take with regard to requests for continuance when an attorney alleges that an opponent has indicated he or she is unavailable for deposition sought to be scheduled 6 weeks into the future because of an alleged full calendar?
Well, I think the practitioners in my district are pretty savvy, and they know that if they come to me and say it's the doctor who did it, I'm going to give them the continuance. And generally it is the doctor who does it. We have a limited amount of doctors in the Sarasota-Bradenton area who even take workers' compensation patients, and some of them say, I'm not going to do a deposition except at 6 o'clock in the morning or 6 o'clock at night, and I have 3 slots, and you can all figure out how you're going to do that. So generally speaking, it is more often the fault of the people they are seeking to depose as it is the lawyers themselves. Now, I recognize that the lawyers often do have conflicts on their calendar such that that first date the doctor gives them might not be the date that they can attend. But in general, I give them leeway, as much leeway as they need when it's within that 210-day time frame. I don't really care if they need to continue as long as they stay within the 210. Once they start getting outside that 210, then I want a little bit more information about whose fault it was, because in fact the rules do say that I'm not supposed to grant a continuance unless the party asking for it can show me that it was not that party's fault that they needed the continuance. It was beyond their control. We in fact need to put that in our orders granting continuances. That wasn't the fault of the party asking for the continuance, that they needed to get it.
Thank you. Judge Lazzara, we're here at a program entitled The New Realities of Workers' Compensation Litigation in 2013. We know that the 2009 legislative changes regarding attorney's fees has reduced to some degree the appetite of many claimants' attorneys to handle smaller cases or small issues because of the concern that the required number of hours would produce an unreasonably low attorney's fee when compared to the hours required. Have you seen in your practice an increase in pro se litigation in the context of cases with dates of accident after 7/109?
Yes. And Judge Benton alluded to it. You know, the title and the theme here is the new reality of workers' comp practice. And the interesting thing, it reminded me when we came up with that title, something Yogi Berra stated, and that is, you know, the future ain't what it used to be. And it's the truth, especially with workers' comp. It isn't what it used to be. And generally, I mean, I'm old enough to remember that every time there was an amendment, and I'm sure Mr. McConaughey remembers, every time there was an amendment, the argument was from both sides of the bar is this is the end of workers' comp, this is the end of workers' comp. But since really the amendments in 2003, there has been a drastic change. There's no question about it. With respect to whether or not there's more pro se litigants, I find that the pro se cases that ultimately go to a final hearing, they don't start pro se. In other words, the litigant, in fact, has an attorney representing, that is, the claimant has an attorney representing him or her at that stage. After mediation, if the case doesn't settle, a lot of times I do get motions to withdraw, especially if there are small issues, such as several weeks of indemnity benefits. Usually it deals more with an indemnity issue than a medical issue, but generally if there's small periods of indemnity, I usually get a motion to withdraw. Most judges, and I think that's probably true of my colleagues, we see motions to withdraw just simply state that there are irreconcilable differences between the attorney and the client, really without really specifying more. And I can understand there's an attorney-client privilege. I had one recently the other day where I get this motion. It was 5 days before trial. I denied it and basically stated there was insufficient information to allow this, and we were just coming up with trial. The attorney files an amended one stating that the reason for the withdrawal was ethical considerations. I will not go any further at that point because there's something that the attorney might know that if he or she divulges it, then it would cause a problem or could prejudice the claimant in some fashion. But what I see and have seen is the fact that most pro se litigants don't start pro se. They tend to end up pro se if the case doesn't resolve at mediation.
How are those unrepresented claimants faring before you?
I can't tell you that they all lose because that's not the case. It depends on certain issues. Some of the cases have already been pre-tried, if you will. So there are certain stipulations with respect to some of the factual issues or the claims that have been raised. But ordinarily, it is difficult. It is extremely difficult for a lay person to sustain, if you will, the burden of proof in the evidentiary requirements that are necessary to sustain a claim, especially since, as a result of the changes, the burden of proof is certainly more stringent. There isn't any question about it. And it's difficult. It really is. Judges are put in sometimes an untenable position because you don't want that claimant to be overwhelmed by the defense attorney with objections. But there's that fine line where the judge can't become an advocate for the claimant, unrepresented claimant, but yet try to maintain a fair process, if you will, and allow that claimant to have his or her day in court.
Thank you, Judge Libera.
Chris, if I could respond.
Yeah, I was going to lead to that because
Okay.
this segues nicely into one of the topics that we were going to be asking you about. I was going to ask you, can you explain the attorney's ethical or professional obligations with respect to motions to withdraw?
Thank you. But before I get to that, because I think you made an excellent point here, which was how are unrepresented claimants faring before us, and but the same would go for unrepresented employers. How do they fare before us? I mean, this is a very complex and specialized area of the law, and attorneys are performing a valuable service. So I think, I just wanted to mention that and have that recognized because, whether it's an unrepresented claimant or an unrepresented employer, they're at a tremendous disadvantage with regard to either proving up or defending a case in this system.
Thank you.
Okay. And then your question was
Yeah,
about...
my next question was, can you explain in a little bit further detail an attorney's ethical and professional obligations with respect to motions to withdraw?
Yes, and thank you. And I did want to discuss that because, as Judge Lazaro mentioned, we often see these brought at the last minute, just before or even at the time of trial. And we have a rule on point, of course, and it's Florida Administrative Code Rule 60Q 6.1042. But it says that an attorney remains the attorney of record until a stipulation for substitution of counsel has been filed and served, or a motion to withdraw, which reflects that it's been served on the client and all other parties, is granted. You should know that if the withdrawal will interfere with the efficient functioning of the court, the judge has the authority to deny a motion to withdraw. Withdrawal from representation of a client is not a matter of right. Case law tells us that in civil actions, the attorney of record has the right to terminate the attorney-client relationship and to withdraw unless the granting of such requests would interfere with the efficient and proper functioning of the court, and that's the case of Martin versus Laidlaw Tree Service. Under the case law, the trial judge has the authority to deny a motion to withdraw even when potential ethical conflicts are presented. And that's the case of Billings, Cunningham, Morgan, and Boatwright versus Esom. In that case, the plaintiff alleged his attorney told him his settlement would not be final. The plaintiff's attorney moved to withdraw on the grounds of conflict of interest. That seems to be a clear conflict of interest. The plaintiff's attorney told the trial court the Florida bar advised him withdrawal was mandatory. After analyzing the complexity of the case, the trial judge denied the motion to withdraw. The appellate court noted that a trial judge's decision to deny a motion to withdraw will not be disturbed on appeal absent a clear abuse of discretion, and found the trial court had not departed from the essential requirements of the law. Rule of Professional Conduct 4-1.16c provides that a lawyer must comply with applicable law requiring notice or the permission of a tribunal when terminating a representation. Absent the filing of a stipulation for substitution of counsel, our administrative code rule requires the JCC's permission to terminate legal representation. An attorney may not just unilaterally decide he or she is off the case and no longer needs to attend hearings, even where the client has fired the attorney, and I've seen that happen on a number of occasions. Pursuant to Rule of Professional Conduct 4-1.16c, when ordered to do so by a tribunal, a lawyer shall continue representation, notwithstanding good cause for terminating the representation. Where there's a pending petition for benefits or a scheduled final or evidentiary hearing, I require a hearing on motions to withdraw, and I request that the affected party also be present. I have a number of reasons for this. I want to ensure that the party has been notified of his attorney's request to withdraw. I want to explain to the party that I'm not permitted to become his attorney or give him legal advice. If he's unfamiliar with workers' compensation law and the benefits to which he may be entitled, and he doesn't know the rules of evidence, the rules of procedure, or how to prove up his case, then I would recommend that he try to obtain alternate legal counsel.
Thank you, Judge Lewis. Judge Beck, we've had some conversation this morning with regard to problems that arise from a failure to act with promptness. One problem area that you've discussed is a failure to serve e-file documents to opposing counsel simultaneously by electronic means. This is obviously fraught with potential for ethical and professional violations if it results in a failure to timely inform one's opponent of a pending pleading or other action. We know that the new rules that came out in the fall under 60Q 6.108 now states that in the event a represented party files a pleading or other paper with the OJCC by electronic means, the party shall be required to serve the other party or parties or their designated representative electronically. Prior to the addition of this provision, was this a problem you encountered in your jurisdiction with some frequency?
Well, I think that it wasn't as noticeable because before this rule change, the next rule before that always did say that you had 15 days to respond to a motion. So even if somebody mailed a motion as opposed to emailing it, there was still enough lag time in there where the opposing counsel could get a copy, review it. Where it becomes problematical is if, again, you've got some kind of time-sensitive issue, and you file a motion for protective order against a deposition that's going to occur in 2 days. And so I might try to get that set on a real quick motion hearing, and often I would hear from the opposing counsel, well, I'm here, Judge, but I haven't even seen this motion yet. I don't know where it is. So it was problematical and can be, and that's where the danger lies, is if you e-file a document with me, I see it the minute you e-file it or within a couple minutes, and you send it by U.S. mail to opposing counsel, they may not get it for up to 5 days. And now that we don't have Saturday mail, or we're not going to have Saturday mail, I guess starting in August, It may even be longer. So that's where the issue is. And, I think people think there's something magical about the internet and about the EJCC filing, and they think that once you put something on there, the whole world can see it, and suddenly they don't have to share it with opposing counsel because it's there for them to look at. But in point of fact, it's like any other document. It must be served on opposing counsel, and if you do it at the same time you give it to me, then everybody's on the same level with regard to what I'm going to look at and what I'm going to be ruling on.
How can a party document they have served their e-file document according to the rule?
All they have to do is include in their certificate of service that they served it by email. And I think what probably has happened is we're all so used to form things. The people haven't changed their forms yet. So the forms still say served by U.S. mail, when in fact they haven't been. They actually are emailing them or electronically serving them. They're forgetting to put that in. And another issue comes if some of your parties are represented but some aren't. So let's say that you have a employer who uses an email address or a carrier who uses an email address and they don't have counsel yet. And so you've got to send some things by U.S. mail to the people who don't have the email address yet, but others get electronic. I think you just have to put that in your certificate of service. I served unrepresented employer by U.S. mail and carrier by email. And then everybody knows what you've done. Now for us as the JCCs, we have a little function when we actually upload an order that we can click on and tell us who will be served. And I believe that will occur for the attorneys as well, as soon as it's all set up where they can electronically serve each other as opposed to just using the email, that you also will have a record. And so you'd have that as a backup to show the court or anybody who's interested about how you did your service that it did occur.
Thank you. Judge Lazare, you have a comment?
One point, and probably Judge Langham could address this better than I can, but when you register, that is the attorneys register for email, or rather register for e-filing, a lot of times the attorney won't put their email address, will put the email address of a staff member, a paralegal. Sometimes you can, and you probably ought to do both. And I think some of the problems, at least that I've heard of, is that if it gets to the paralegal or secretary puts it on the desk, but it's over a pile of things, and they never actually see the motion because it didn't trigger on the attorney's computer. And I think that's a dilemma. I mean, you need to really discuss this with your staff, or make sure, that there's a change with respect to, the registration, who you want information to be sent to for purposes of the electronic docket.
Thank you. I want to move briefly into the next segment of the program, which is ethics and professionalism in the context of fees, costs, and the settlement process. Judge Lazare, one of the contexts in which ethics and professionalism occasionally arise with regard to attorneys' fees and costs, I have a few questions for you. Can the parties, claimant and defense attorneys, together stipulate to the payment of an alternative medical-only $1,500 fee under 440-34-7 when the record shows and counsel know that the PFB which gives rise to such fee is not a medical-only claim? And if that were to occur between the parties, could the judge approve such a fee?
I don't think so. And I will not approve fees where I find that they're not, in fact, a medical-only fee. That is, if there's a request for approval of a medical-only fee. Why is that? Well, we have to go back. Remember, we are not Article 5 judges. Whatever authority or jurisdiction we have is conferred to us pursuant to Chapter 440. And if Chapter 440 says to have a medical-only fee, it has to be within the definition of 440-34A, which basically says a petition or claim that does not include an indemnity claim or the possibility or the potential of including an indemnity claim. You're not entitled to a fee under 440-34-7, which is the alternative fee for $1,500. Can attorneys stipulate to that? The problem is that generally, when I see or receive a request for approval of an ex parte fee, it's at the time of settlement. And that's the crux of the problem, unfortunately, is when there is finally a pot of money, if you will, that can be divided up. And if, in fact, the parties stipulate to a medical-only fee when a medical-only fee is not called for, not that the attorney didn't obtain that medical benefit. There's a possibility that that attorney did, in fact, obtain that medical benefit. Therefore, there still is entitlement to a fee, and it might be at the expense of the employer carrier. But because of the fact that the alternative fee provision or medical-only fee provision applies only to cases where it's a medical-only claim, the fee would have to be calculated pursuant to 440-34-1, and that is a percentage fee based on the value of the benefits. So the short answer is, if I find that there is no entitlement to a fee, even if to a medical-only fee, even though stipulated, I will not approve it.
Thank you. Judge Lewis, can you guide us through some of the potential conflicts of interests and ethical considerations arising from fee disputes and motions to enforce settlements?
Sure, I'll try. I did want to mention one thing about the medical-only petitions, because there's an interesting case out there, and I haven't done exhaustive research on this, but there's at least one case, and that's Landers Construction versus DeLauder, and it's at 417 Southern 2nd 989, 1981 case of the first ECA, where a claim for authorization of surgery and continuing temporary total disability after the surgery did not disqualify the claim as being one for medical benefits only. The temporary total disability claim was considered to be part of the claimant's essential medical care. So I just wanted to mention that, because it may not always be exactly clear as far as what is a medical-only claim. Is a claim for adjustment of average weekly wage and medical benefits a medical-only claim? And this is something that you all can go out and research, because that portion of the statute dealing with medical-only claims has been in there for a good long time. But as far as fee disputes and motions to enforce settlements, Rule of Professional Conduct 4-1.7 is the conflict of interest rule, and that rule provides in part that a lawyer shall not represent a client if there's a substantial risk the representation will be materially limited by a personal interest of the lawyer. Rule 4-1.7b says that if there is such a conflict of interest, the lawyer may continue representation only if the lawyer reasonably believes she will be able to provide competent and diligent representation, the representation is not prohibited by law, the representation does not involve the assertion of a position adverse to another client, and each affected client gives informed consent in writing or on the record at a hearing. Now, conflicts of interest, as you know, frequently arise in the context of fee disputes. In his article, How to Handle Lawyer-Client Fee Disputes, Assistant Florida Bar Ethics Counsel Jeffrey Hazen tells us that if a fee dispute has made it impossible for the lawyer to place the client's interest ahead of his or her own, a conflict exists and the lawyer should move to withdraw. So that's the test. Can you place the client's interest ahead of your own? Attorney Hazen tells us that in Florida, unlike in many other states, the case file is considered to be the personal property of the lawyer. That's the case of Dowda and Fields versus Cobb. If the lawyer withdraws, she may assert a retaining lien over the case file. However, the lawyer still has an ethical obligation to avoid prejudice to the client's interests. For example, if the client has a pending trial or an imminent deadline, the lawyer may have to provide portions of the file to the client to avoid resulting prejudice. Conflicts of interest also arise in conjunction with the seemingly ubiquitous motions to enforce settlements. We see quite a few of those. In such situations, attorneys may be pitted against their own clients. Once again, the attorney may have to withdraw if the attorney's and client's interests are divergent, assuming the trial judge allows the withdrawal. Certainly, if the lawyer will be testifying against her own client, that's a conflict of interest. Also, with respect to motions to enforce settlements, there's some interesting case law out there, and that law tells us there's no attorney-client privilege where a communication is relevant to an issue of breach of duty or alleged breach of duty by the lawyer to her client. That's the case of the estate of Tobias versus Barnaby. For example, in a hearing on a motion to enforce settlement, if a client asserts that her attorney settled the case without her authority, the attorney-client privilege is waived as a matter of law. And that waiver, by the way, is codified in the Florida Evidence Code. Section 90.5024C of the Evidence Code provides that there is no lawyer-client privilege when a communication is relevant to an issue of breach of duty by the lawyer to the client or by the client to the lawyer arising from the lawyer-client relationship. The case of Hamilton versus Hamilton Steel Corporation tells us that no court should countenance an announced settlement between counsel, followed by an escape therefrom, if one side arbitrarily reneges and then seals his counsel's lips by invoking attorney-client privilege. Under the sword and shield doctrine, a party who raises a claim that will necessarily require proof by way of a privileged communication cannot insist the communication is privileged. And that's the case of Jenny versus Air Data Wyman, Inc.
Thank you. We have one last section, and then we're going to open up the floor for some questions, and this is pertaining to some current trends in litigation. Judge Lazzara, we know that the statistics are showing that the number of trials, final hearings before judges of compensation claims are down considerably in recent years. Some of the explanations obviously would seem to be the use of EMAs to resolve medical disputes, perhaps the trend towards seeking costs from injured workers who do not prevail in litigation, and as we've discussed this morning, perhaps the changes to the attorney fee provisions under the 7109 law. What types of issues or disputes are you seeing more frequently that now require judicial resolution?
Right. There's no question that final hearings are down. The numbers prove that out. But what I'm seeing is an increase of things that we didn't see before, and that is motions for advances, which we rarely ever saw before. I mean, they would occasionally pop up. Most of the time, they were resolved. But we do see motions for advances. And, of course, the new type of motion filed by employer carriers, and that is for taxation of cost when either the carrier prevails or the petition is dismissed. What I'm starting to see, and I've had a few cases which I didn't before, and that is apportionment issues, apportionment claims. And carriers frequently, or rather defense attorneys frequently, did not raise that. But I'm starting to see some. I had recently, had a final hearing recently in Live Oak, and that was the issue. It wasn't so much whether or not the surgery was authorized or not authorized or reasonably and medically necessary, but the issue really was the actual cost. You had a physician that basically stated that the major contributing cause of the need for surgery was the subject work accident, and that was at 51%. But the other 49, and that's where it was a problem, was as a result of a pre-existing condition or prior occupational injury that the claimant had. So the carrier was willing to authorize the surgery, but was only willing to pay 51% of that. The real problem with apportionment cases, I find, and as I had in this one particular case, deals that physicians have a real hard time trying to apportion, if you will, the causative factors of why there is a need for particular treatment. Most physicians are not so much interested in the cause as it is the condition and treating that condition. So as lawyers and as judges, a lot of times we put them in an untenable position in trying to figure out what the percentages are. But those are the type of cases that I generally see. That in reviewing attorney's fee issues at the time of settlement.
Sure.
Those have increased.
Judge Beck, I'd like to open the floor to you very briefly. What are some of the things you're seeing most in your area in terms of things going to final hearings?
Like Judge Lazzara, I'm seeing the motions for advances, and I'm seeing a lot of motions to enforce settlements. That seems to be a big one, and either the claimant gets buyer's remorse and decides they don't want to settle anymore, or there's issues where they made it contingent on an MSA and now something's going on with the MSA, or they're fighting over whether they really agreed to fund extra things. So I see a lot of that. If I do have a merits hearing, it tends to be either a permanent total disability claim or a compensability issue or a fraud issue. So those seem to be, you rarely see a little one-issue case like an authorization of surgery or an authorization of a scooter, unless, of course, the date of accident is earlier and the fee ability to get a good fee is still out there, then they will litigate the little issues. But the issues that I see tend to be either big issues, but I agree that the trials are down, and from what they were, and that we're seeing more of the evidentiary kinds of motions rather than full-blown merits hearings.
Judge Lewis, your thoughts?
Yes, another one that hasn't been mentioned, of course, is the evidentiary motions for summary final order. We see those quite frequently these days. But it's true that the trials are down, but I think they've been replaced to a great degree by all of these evidentiary type motions that we get. And sometimes motions to dismiss are being used almost as a motion for summary final order, which is not appropriate because it doesn't comply with the procedural requirements of the summary final order rule. But be that as it may, again, like I said, we do see a lot of evidentiary type motions. And also, I did want to say before closing is that I have found the vast majority of attorneys, adjusters, and claims personnel, which is all of you, to be very ethical and professional, and I just want to say keep up the great work.
Thank you. Appreciate your participation, all of you. Wanted to take a few moments to open up the floor for questions for perhaps about 5 minutes. Sir.
I've got two comments and one question. My first comment is the hearings may be down because of the effectiveness of the state mediator.
Very true.
Here, here. Point well taken.
The other comment is when you have a claimant appearing by phone and there's a settlement, I would suggest to the claimant attorneys to have the mediator in the room when they ask their claimant if he or she agrees to the settlement. Once the settlement agreement is entered into, my understanding of case law is that confidentiality no longer applies. And if the claimant should attempt to back out, I believe the mediator could then testify that he heard the claimant explain the terms of the settlement and that the claimant agreed to those terms. My question is this, going back to Judge Lazara's comments about attorneys withdrawing after mediation. I've seen that happen where the attorney has said, I'm going to represent you through mediation, but if you don't settle, I'm pulling out because it's just not going to be cost effective for the claimant attorney to go forward. In some of those cases, the claimant attorney will dismiss the pending petition before he or she withdraws. My question is, does that create an ethical problem for the attorney? Because based on the first DCA decision a couple of years ago, that could expose the claimant to taxation and cost by the employer carrier.
Would any of you like to take a swing at that one?
Yeah, I would. I agree. I agree with the comments that Mr. Hardy stated or made. Generally, when I get a motion to withdraw, there's not a withdrawal of the petition in most instances, and I think it's for that reason that the attorney may not have the permission to do that. But what I generally see, and there is case law. Excuse me, there is an ethics opinion by the Florida Bar. It's a very old ethics opinion, and there was a workers' comp, and specifically a workers' comp attorney was asking to withdraw or determine whether it was proper to withdraw as a result of not wanting to handle an appeal. This is at the time when the RSC was around and the Supreme Court was awarding attorneys fees of $500 to $750 for an appeal, wanting to withdraw, and the Florida Bar said that was not a basis for appeal. But along the same lines, there is something that the Florida Bar has called, I believe it's bundling of services. And you ought to look it up. That is, an attorney can, in fact, withdraw at a certain point in a litigation so long as there's full disclosure to the client. For instance, if a claimant's attorney advises the claimant that I am only going to represent you through mediation and not any further, there are certain rules, I think, that the Florida Bar has in place that you can, what they call bundle services, so that you're only providing services just for a limited purpose, but only for a limited purpose. I don't think that's generally done in workers' comp. I think the withdrawal is because the claimant's attorney doesn't want to put more time into the case simply because the fees wouldn't be there, or the cost advancement would be prohibitive. But I wanted to mention that there is a provision for bundling of services that the Florida Bar has.
Thank you. Judge Lewis or Judge Beck, anything that you'd like to add?
In Sarasota, I see some of both, where the claimant's attorney will withdraw the petition and then withdraw, or leave the petition pending and then withdraw. If the attorney leaves the petition pending and withdraws, depends on how far along we are in the process. If we're already past mediation, or if the final hearing's coming right up, I will write to the claimant and say, your attorney's withdrawn, and we can't give you legal advice, but I need to know whether you want to go forward or not. So let me know in 30 days whether you want to continue to prosecute your petition. If I don't hear from you in 30 days, I'm going to assume that you don't want to go forward, and I'm going to go ahead and dismiss your petition without prejudice. And the reason I do that is, if you just leave those hearings on there, it's generally very expensive for everybody, because the EC doesn't know, do they have to defend a trial? What do they have to do? And they show up with all their witnesses, and then the claimant will come in, either not show up at all, or come in and say, well, I'm still looking for another attorney, or I do want to go forward, but not today. And so this, and in doing that, it'll be about 50-50 over whether the claimant will respond or not. Often the claimant will say, yes, I do want to go forward, but I'm looking for an attorney. Then I'll go ahead and put the things back on the calendar, a few months down the road to give them time to get a lawyer. Other times they never respond, and I go ahead and enter a dismissal without prejudice, which I think would not allow the employer carrier necessarily to come back as the prevailing party under just a dismissal, because I'm the one doing the dismissal. It's not a voluntary dismissal.
Very good. Judge Lewis?
I'd be a little concerned about that, because unless there's a lack of prosecution or some other basis to dismiss, writing to the claimant and saying I'm going to dismiss within 30 days, I'd be a little concerned whether that could be challenged at some later point. But that's why I try to have hearings on the motions to withdraw, because after the mediation, you very likely got a trial set, or maybe even before the mediation, and so therefore you've got hearings coming up, and I do request, and sometimes the affected party doesn't show up, but hopefully they will, and I can explain their rights better to them at the hearing.
Thank you.
I was about to say, I agree with Judge Lewis, especially if the hearing is just coming up fairly soon. Two reasons. Number one, a lot of times if you don't, the claimant appears at the trial and then says, I'd like additional time for purposes of trying to obtain an attorney. This puts the defense in a situation where they have to file whatever depositions they have, prepare for trial, and that's an unwarranted expense. I think sometimes just conducting a hearing on the motion to withdraw becomes more of a status conference to find out whether the claimant wants to proceed with the case or not proceed with the case, and I think it puts the parties in a better position. The second thing is, the old Supreme Court rules in workers' comp used to provide a form, and the form in the order stated that, especially in cases where the claimant's attorney is unable to communicate with the claimant, that there was a period of 30 days within which to respond or have an objection. I think you really ought to include that in the order still.
And there is case law out there, not necessarily in workers' compensation, but in other areas of the law that says when you allow an attorney to withdraw, you should not take any action against the claimant in any way for at least 30 days to allow them the opportunity to get counsel. In other words, you shouldn't set depositions, or you shouldn't set hearings or other sorts of things just for that period of time to allow them to get another attorney should they so choose.
Thank you so much. I really appreciate your participation. We are running about 5 minutes over at this point, and the next session starts in 5 minutes downstairs. What I would like to do is invite anyone who has any additional questions to just approach afterwards.
I do want to make a quick comment.
Okay, go ahead.
The service portal on the EJCC is up and running. After you refile a document, you just kind of scroll down a little bit, and there's a button to hit service, and then it gives you the option to just click on which email addresses, which correspond with the email addresses that are on file. So everyone should be served automatically when they refile.
Thank you so much. I appreciate that.